So friends, even though the Supreme Court has put a temporary hold on Donald Trump's federal prosecution in D.C. for trying to overturn the 2020 presidential election, that case could still go to trial before the November election. So, yep, I'm saying there's a chance. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, with the Supreme Court grabbing hold of the absolute presidential immunity issue and putting Donald Trump's federal prosecution in D.C. on hold while they decide that issue, can the D.C. case still go to trial before the November election? The answer is yes. Will Donald Trump's federal prosecution in D.C. go to trial before the November election? The answer is don't know. So friends, let's start with the new reporting, and then we're going to take a few minutes to chart out the possibilities, even if not the probabilities, of Donald Trump's federal prosecution in D.C. going to trial before the November election. Let's start with the new reporting from USA Today. Headline, How a Trump January 6 Case May Still Go to Trial Before Election Day, Despite Supreme Court. And that article begins, Despite recent complications, there is still a good chance Donald Trump will be tried on allegations of illegally trying to overturn his 2020 election loss before he faces the judgment of voters on Election Day, legal experts say. But Trump's efforts to throw one wrench after another in prosecutors' way means that they will be scrambling to bring to trial the separate election interference cases they have spent years building against the former president in federal court in Washington, D.C. and state court in Georgia. Now, friends, for purposes of our discussion today, we're going to set to the side the Georgia state case, the RICO case that's being prosecuted by District Attorney Fani Willis, at least until the current litigation sorts itself out and we have a clearer picture of the timetable, the possible timetable of a prosecution down in Georgia. Today we're going to focus on Donald Trump's federal prosecution in D.C., the one being prosecuted by Jack Smith and presided over by Judge Tanya Chutkan, and we're going to chart out the possibilities of that case going to trial before November. The USA Today article continues. The biggest roadblock to getting the federal trial underway was the Supreme Court decision on Wednesday to schedule arguments for the week of April 22nd on whether Trump can be prosecuted by special counsel Jack Smith or whether presidential immunity is so absolute that it covers all of Trump's, alleged misdeeds, alleged crimes, while trying to stay in office, as Trump claims. Special counsel Jack Smith had asked the court to hear the arguments at least a month or so earlier. Then this quote from Representative Dan Goldman himself, a former federal prosecutor, quote, I think if the Supreme Court decisively decides the immunity issue, and I cannot fathom a way that they would rule in favor of Donald Trump, that there is still time to have a trial before November, said Representative Daniel Goldman, a former federal prosecutor. Okay, friends, let's spend a few minutes charting out the possibilities. I can't say they're probabilities, I can't say they're likelihoods, because only the Supreme Court knows how long the Supreme Court will take to resolve Donald Trump's absurd, absolute presidential immunity claim, and only the Supreme Court knows how it will resolve the presidential immunity claim. So let's talk about the different possibilities. So last week, the Supreme Court said, we've decided we want to hear arguments on the presidential immunity claim. That being, a president of the United States can commit all the crimes he wants against the American people in violation of our federal laws to try to criminally and unconstitutionally retain the power of the presidency, and he can do it with absolute impunity and immunity against prosecution. That's Donald Trump's claim, and the Supreme Court has now said, oh, we're sufficiently interested in that claim that we're going to order oral arguments, and we're going to set those oral arguments for, a couple of months down the road, the week of April 22nd. Because, what is the urgency in resolving the question of whether the leading Republican candidate for president can be criminally prosecuted, convicted, and imprisoned for trying to overturn the results of the last election? We'll just go ahead and take our time. They could have set it for 2 weeks out. They set it for 2 months out. That's a red flag, in my opinion. But they said, we will hear oral arguments the week of April 22nd. What does that mean? Let's talk about the possibilities. Let's assume they hear arguments the week of April 22nd and they issue an opinion quickly. Let's just say May 1st. So, first of all, if they decide that a president has absolute immunity and can commit crimes to retain power, what happens? Well, that's the end of our democracy. That's not hyperbole. That literally sets up the end of our democracy, because presidents can commit all the crimes they want to try to retain the power of the presidency, and they can't be prosecuted for it. Assuming they don't rule that way, and I think there are very few experts, constitutional scholars, or human beings who can think critically and have any common sense, who would say, yeah, that's what America is all about. Presidents getting to commit all the crimes they want against the people they're supposed to be representing, and do it with complete immunity. So assuming they don't rule that way, assuming they rule, no, president does not have absolute immunity, he can be criminally prosecuted, and they hand that ruling down on May 1st, then the case immediately goes back to Tanya Chutkan, the presiding judge, to be put back on the trial track. What does that mean for timing purposes? Well, Judge Chutkan has said, look, when the Supreme Court first paused my trial, or when the appellate court first paused my trial, we were about 88 days away from the trial beginning. It was supposed to begin on March 4th. So she said to the parties, the defense and the prosecution, I'll give you about 88 days when I get the case back. Let's round it up to 90 days, 3 months. What would that mean? Well, it would mean if she gets the case back on May 1st, then the trial could start on August 1st. The prosecutor said it's going to take about 6 weeks, which means the trial could be wrapped up by mid-September. And Donald Trump will have gone to trial before the November presidential election. That is perhaps the best case scenario, and it's certainly a possibility. What's the next possibility? Well, let's assume the Supreme Court hears oral arguments the week of April 22nd, but they don't resolve the case. They don't decide the case promptly. They let their ruling linger until the very end of the Supreme Court's term. The last day of the term is June 30th, and they hand the opinion down on June 30th. Well, let's go back to our two possibilities. If they rule the president has absolute immunity, he can do these things without being prosecuted. That equals the end of our democracy. Again, not hyperbole. If they rule, nope, no immunity, they give the case back to Judge Chutkan again to be put on the trial track. Well, if she sticks with that 88 or 90 days, what does that mean? If she gets the case back on, say, July 1st, then she puts it back on the trial calendar, and gives the parties 90 days, well, that means the trial doesn't start until October 1st. And if it's a 6-week trial, that means when November 5th rolls around, they're still in trial. Donald Trump is still being prosecuted for the crimes he committed on and around January 6th. Not ideal, but perhaps not the worst alternative, because at least he's in the process of being federally prosecuted for his democracy-busting crimes, even if that trial continues through the next presidential election. So friends, in a very real sense, the resolution of this issue and whether Donald Trump's trial will be conducted and concluded before the November election, that remains in the hands of the Supreme Court. Not the world's most comforting thought, I know. But let's talk about some of the other possibilities. Here's another possibility that is of some concern to me. Sometimes the Supreme Court will take a case for review and they will decide that the record needs more factual development. What do I mean by that? Well, the Supreme Court doesn't resolve disputed facts. The lower court, the trial court, resolves all the disputed facts, and then the legal issue gets presented to the Supreme Court. But if the Supreme Court feels like there are still some open questions of fact that they need resolved in the crucible of a trial, in a motions hearing conducted in a trial court, they will remand the case back down to the trial court with instructions that we want these 3 factual disputes resolved by the trial court, and then send the case back up to us. Why might that be in play here? Well, it really comes down to the nature of the question that the Supreme Court directed the parties, the defense attorneys for Trump and the prosecutors, to address in the oral argument on the week of April 22nd. The Supreme Court said the petition for review is granted, limited to the following question: whether, and if so, to what extent, does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? And it is that official acts piece that gives me a little bit of concern. I don't think the Supreme Court needs to send the case back down to the trial court, to Judge Chutkan, to hold an evidentiary hearing on whether these allegations in the indictment of Trump involve potentially official acts of a president or not. They're clearly not official acts, but I have some concern that if the Supreme Court wants to try to run out the clock and do a big favor for Donald Trump, they could use as a vehicle a remand and say, well, Judge Chutkan, we need you to take this case back and hold all kinds of evidentiary hearings on whether these allegations against Donald Trump constitute official acts or not. And after you take the necessary time, probably several months, to resolve that by litigating the issue in the trial court, just go ahead and return the case to us. And then we promise we'll get right back on deciding whether Trump should be immune from prosecution for everything he did on and around January 6th, everything for which he's been criminally charged. That's a concern I have, because they could basically use that as cover. They could use it as a ruse, giving the case back to Judge Chutkan and ordering her to conduct all kinds of evidentiary hearings on factual questions that they feel they need resolved before they can then resolve the legal issue. One other thing that gives me some concern: Judge Aileen Cannon down in Florida, Donald Trump's favorite judge, never uttered a cross word about her, unlike every other judge that has been involved in the endeavor of trying to hold Trump accountable for his crimes. So Judge Cannon had a hearing in the Florida prosecution a few days ago, and she had previously set a trial date, May 20th, right? That was a date that actually Donald Trump's lawyers many months ago said, That's good with us, Judge. And what has happened there? Well, what's happened there is during this hearing last week, Jack Smith modified the request for a trial date. The reason he modified it was in recognition that Donald Trump is about to go to trial up in New York, right, for interfering with the 2016 presidential election by making hush money payments to try to hide deeply damaging information about him from the American voters, so he could basically rob the voters of the full value of their vote in 2016. And then he covered up his hush money payments by committing 34 felonies, falsifying business records to lie about these hush money payments. It's a very strong case on the evidence. So in recognition that that case is about to go to trial starting on March 25th and maybe go to early May, I think Jack Smith said, well, Judge Cannon, then we're asking for a modified trial date in Florida, not May 20, but July 8th. Give the defense some time to get ready for that trial. And what did Donald Trump's lawyers say? Well, first they said we can't possibly go to trial before the election, but they said, push comes to shove, we can accept an August 12 trial date. But Judge Cannon, taking those two requests, prosecutor asking for July 8th, defense asking for August 12th, she said, I'm not going to make a decision. I'm not going to pick a new trial date. Curious. So right now, the trial date in Florida is in limbo. Here's my concern, friends. Stick with me here. I'm almost done. My concern is that Judge Cannon, sometime in the coming days or weeks, will say, I'm prepared to pick a new trial date. And let's, for the sake of argument, say that she picks August 1st, kind of splitting the baby between what Jack Smith asked for, July 8th, and what Donald Trump's lawyers said was acceptable, August 12th. August 1st, that will be our trial date. Then let's assume that the Supreme Court in April or May resolves the absolute immunity issue, says Donald Trump has no absolute immunity, gives the case back to Judge Chutkan, and she has to set a trial date. What's the problem? The problem is, Trump's team is going to run into Judge Chutkan's courtroom and say, Judge Chutkan, we have an August 1st trial date in Florida. We're sorry. We would love to go to trial in the federal election interference case, but we can't. We had to block out all this time on our calendar now. And of course, they would never say they would love to go to trial. I found it curious that they told Judge Cannon, Donald Trump's lawyers, we can do August 12th. That, to me, felt like a move designed to get an August trial date on the calendar to box out Judge Chutkan if she gets the case back from the Supreme Court and could otherwise try it beginning on August 1st. Pretty shrewd, right? Pretty nefarious and a little dirty, playing one court against the other to try to keep yourself from going to trial in any case. Friends, as a 30-year prosecutor, do you know how many times I had defendants with multiple trials in front of different judges try to play one judge against the other and try to push all of the trials down the road as far as humanly possible? Something prosecutors have to contend with and combat, not infrequently. And then let me finish, and this is now becoming a parade of horribles, because if we assume the Supreme Court rejects absolute immunity and on May 1st gives the trial back to Judge Chutkan such that she could start the trial on August 1st, but now there's an August 1st trial date down in Florida, here's what is likely to happen. Please bookmark this. I don't know what bookmark means. I am so bad at the computer, I can't even spell IT. But please remember this, because if there is an August 1st trial date put on the calendar by Judge Cannon in Florida, here's what I can almost promise you will happen. After Judge Chutkan realizes that the August 1st trial date has now been taken, and she has to set her trial against Donald Trump, the federal election interference trial, well after the election, with the assumption being Donald Trump's going to be in trial in Florida, August, September, October. A couple of weeks before the August 1st trial date in Florida, Donald Trump's lawyers will gallop into court sometime in July. Oh, Judge Cannon, there's been a late disclosure by Jack Smith, or we just came up with this other batch of evidence that we really need more time to look into, to investigate, to assimilate, to deal with before our trial starts. So we are no longer prepared to go to trial on August 1st. What we really need, Judge Cannon, do us another solid, Donald Trump's favorite judge, is for you to give us a continuance in the August 1st trial date until after the November election, if you kindly would do that for us. Now, if she grants that, she has both successfully boxed out Judge Chutkan from taking Donald Trump to trial before the election in the 2020 election interference case in DC, and she has given Donald Trump a pass from having to go to trial in the classified documents, unlawfully retaining classified documents, obstructing justice, espionage case that's been brought against him in Florida, if she grants Donald Trump's motion to kick that trial date from August 1st until after the November 2024 presidential election. And yes, that's a parade of horribles. It's a big bucket of nefarious conduct by Trump's team. But isn't that what we have come to expect? So friends, now that we've unraveled the possibilities, if not the probabilities, let's go back and look for that little bit of silver lining that is always lurking behind the big orange dark cloud that is Donald Trump. And let's go back to where we started on our chart of possibilities, because there is a possibility, a legitimate possibility, that the way it will play out is the Supreme Court resolves the case sometime in April or May, returns it to Judge Chutkan, and it gets put on the calendar to be tried and resolved in advance of the November election. That is still a significant possibility, even if I wouldn't call it a probability or a likelihood, but that's what should happen, because you've heard me say before, friends, the American voters have every right to know when they go to the polls, in the event they're contemplating casting their vote for a career con man and criminal, they have every right to know if the person they're casting their ballot for is a convicted felon who has been convicted of criminally trying to overturn a presidential election, trying to override the expressed will of the American voters, or if he's gone to trial and been found not guilty by a jury of his peers on all counts, whether they're casting their ballot for a completely exonerated person, innocent of all charges that were brought against him. The American voters have a right to know that come election day. And that's why we're going to stick with the hope, even if not the probability, that Judge Chutkan gets the case back after the Supreme Court rules that a president is not a king and can be prosecuted for his crimes while in office, and that case resolves itself prior to the election. That's the way it should play out, and that's what we are going to be hoping for and pushing for in every way we can push. Admittedly, we don't have a lot of concrete ways we can push, but that's what should happen, because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.